Most property owners in New York City treat new construction like this. If I build anything that's attached to my building, I own it. But that's not always true, because in New York City, the sidewalk, the space underneath it, and even the airspace around your building can legally belong to New York City. And if your structure extends into that space without permission, you could run into serious problems later. I'm talking about block sales, project delays, violations, legal issues, insurance problems, or expensive removal requirements resulting in civil penalties. I've been dealing with NYC DOT approvals for over 21 years, and one of the most misunderstood approvals in the entire city is called a Revocable Consent Agreement. So in this video, I'm going to explain what it is, why New York City requires it, and why some buildings can legally use the city's right-of-way, while others can't. What is a Revocable Consent Agreement? A Revocable Consent Agreement, usually called an RCA, is legal permission from New York City allowing a private structure to occupy or encroach on city-owned property, also known as city right-of-way. That's the important part. The structure may belong to you, but the property underneath it belongs to the city. And New York City wants a formal legal agreement acknowledging that. This legal agreement also comes with city fees for ongoing use that can range from $100 to $500 per year. Not to mention money, usually in a few thousands of dollars, to be left in escrow for a city coffer that you'll never see again for the lifetime of the Revocable Consent Agreement. A lot of owners are shocked and downright upset when they first hear this. They assume if the newly built structure is attached to their building, it's allowed. Common examples in New York City. These agreements are much more common than people realize. Throughout New York City, these are vaults underneath sidewalks, cellar entrances extending into the pedestrian space, sidewalk cafes, handicap ramps, canopies, conduits, bridges between buildings, and other structures occupying city property. Some of these structures have existed for decades, and sometimes the current owner inherited the problem without even knowing it. Don't think that because something has been there means that the legal paperwork has been filed and exists for it. And if you're already dealing with an underground vault, a sidewalk cafe, or another structure extending into New York City property, send me the address and the type of structure you have using the link in the description below. Because if this issue is tied to your building, it's much better to identify it now than discover it during a sale, refinancing, or major construction project later on. Why New York City cares? This is the part most people don't understand. New York City is not just trying to make construction difficult, the city is trying to control pedestrian safety, utility conflicts, maintenance responsibility, insurance coverage, emergency access, and legal liability involving public space. Because once private structures start occupying city property, someone has to legally be responsible for them. That's why revocable consent agreements exist in the first place. The word revocable matters. A lot of people skip right over this word, revocable. That's the word that matters, because the city is allowing the structure to remain, but technically retains the right to revoke that permission under certain conditions. That doesn't mean New York City randomly removes structures every day, but it does mean you do not permanently own that public space. You're being granted permission to use it for your own benefit. That distinction becomes very important legally, as it gives the city the right to take back that space if they have plans to upgrade the roadway and sidewalk. When people usually discover this problem? Most owners don't discover this proactively. Usually, the issue appears during property sale, refinance, a DOB filing, a sidewalk cafe application, or a major renovation project. Suddenly, someone says, wait, there's no revocable consent agreement for this structure. And now a problem that may have existed quietly for years becomes urgent overnight. Why these projects take so long? This is not a simple permit process. In fact, it's the exact opposite of simple or easy. These approvals involved DOT review, community board review, property surveys, title work, engineering plans, insurance requirements placed on the property owner, maintenance obligations, and coordination between multiple city agencies. That's why these projects can take 4, 6, and sometimes as long as 9 months depending on complexity and location. Because this is not just paperwork. These are legal agreements between homeowners and the city involving public right-of-way in New York City. If you own a property with a vault that extends beyond the curb, sidewalk or roadway cafe, wrought iron fence, underground structures, canopies, or any permanent structure extending into New York City property, it's important to understand whether a revocable consent agreement may be required. Are you unsure if you qualify for a revocable consent agreement? Send me your address using the link in the description below, because it's much easier to identify the issue early than discover it later on during a closing, a refinance, a renovation, or construction project. I've filed dozens of these agreements over the years, helping homeowners and developers. I understand when they're required and how to get them approved with the least friction possible.